Good morning, coffee crew. Good morning. Oh, oh, just got Deb in here right now. It's a little chilly here this morning. Bear with me, I'm just. So Deb, if you don't understand what I was saying there, it's your profile icon, the one that says D. If you click on that, then you should be able to change it. Good morning, everyone. Looks like we got 5 people here. We're just going to go right in here and start getting ready for this. Good morning, Matt. Audio is great. Good morning. Oh, I don't even think I'm awake yet. I'm serious. Metrics is Discord's going off. Look at her mug. We got her up already. Good enough time for us to have our coffee and good morning, Anne. Hello, everyone. Long time no see, right? Oh, these Donna trials. So I went and watched Mentor Lawyer after. I'm really glad that he's seen what I saw about Robert, but I guess that's going to be dealt with today, but behind the cameras, not in front of the cameras. So we'll know if he's not able to be a witness, my lord, gone. If they put out a new witness list. Because there's going to be more than a dozen. So why go in the middle of the hearing, try to get it lowered when I can do it right now? But good morning to you. How did we do? Hi, good morning, Paul. This is a rare treat, my favorite show in the daytime in the UK. I know. Well, soon it's going to be all daytime shows through this trial. Remember, Sunday night is going to be or Sunday at midday is going to be the members only show. Good morning, Jamie. Okay. I just answered that, so I'm not going to answer it again. Can't wait. I'm taking time off work. Yeah, I worked my schedule out for it too. I wasn't missing Donna's trial. I'm going to say this one more time because Frog is on. Didn't hear me the first time. I just went ahead and put slow mode on because I know it's going to get busier and I don't want to interrupt. I want to hear everything at the hearing. And that's fine. Frog is on. If you need to unsubscribe because I put slow mode on, you're more than welcome to do it. Good morning, Chrissy. Good morning. Good morning, Faze. Hey, what's that you and mentor lawyer agree about Rob Adelson being nosy, I guess? No, don't. You're not being nosy. It's a good question. As soon as I seen the motion to seal, I instantly thought it was about Rob and all of that. And mentor lawyer confirmed it last night that it was about Rob. So I'm just really glad that mentor lawyer and I are on the same wavelength. So that's what it is. We just agreed. Good morning, Patricia. I have a very good attitude, Frog is on. It's early. This trial means a lot to people. So if I put the slow mode on so people can be seen and heard, and that bothers you, then I am sorry it bothers you. And you can call me rude all you want. I don't think there's anybody that's in this community that would call me rude. So thank you for your input. I just don't have time for it today. Good morning, Angel Baby. Good morning, Lee. Good morning, Karen. Good morning, Ball. Thank you, Chrissy. Chrissy, am I coming across rude to you? Thank you, Jamie. Good morning, Tracy. I didn't think I was coming across rude. I just knew we were going to get many people in here today, and I didn't want to have to myself interrupt the hearing to change the mode of. So I just did it. I did it last night when I did the thumbnail. Hey guys, what do you think of the thumbnail? Thanks, Tracy. Thank you guys so much. Yeah, it was like the second thing in here. Why slow mode? I was like, because I wanted to. I don't know. Now that was rude. Really, what the hell? Someone woke up on the wrong side of the bed and it was not you. Thank you. Good morning, Michael. And then I'm going to unsubscribe. Okay. All right. I don't like losing subscribers, but really, it is what it is. I haven't even checked this morning what our subscriber count is. 1846, guys. Let me just refresh that just in case. Is that what our count is this morning? Yep. Oh, thanks, Deb. I took it as a screenshot off our last one, the last meeting, and I had a little bit of a logo there. So I put the burger by Rashi. I was like, okay, I'll figure this out. Oh, how much time we got? 22 minutes before it starts. Yes, please like that like button. Did that person leave? We haven't seen anything from them. Oh, sorry. Good morning, Shraz. Good morning. They probably weren't even subscribed. Good morning, JRZ. Oh, you know what? Jersey girl. Oh, I get you. See, I just need to be awake. Jersey girl. That's what it is. Is there another Adelson hearing today? Yeah, it's the other motion. Today's got a motion hearing and then the 12th. And then we will be jumping into jury selection on the 17th. I just had to really look close. I'm like, oh, that says Jersey girl. I hope Sergeant Corbett is allowed to testify. He was awesome with all the calls. I think he'll be allowed to testify. I think it's going to come down to where he can't state his opinions. I don't know Donna was going to be back today. Oh, you didn't know Donna was going to be back today, Karen? Yeah. They said it in the last one on the 6th. 6th and then the 12th, and then 2 days of boring jury selection. Unless something goes really crazy. Oh, we're just waiting on them. So I might as well get. It's not open yet, so I can't. "8:39 p.m. where you are." Well, that's you're in. Are you in Australia? No, you'd be a day. Well, I guess maybe. I can't remember, Ahmed. I'm sorry where you're from. When someone says they're unsubbing or leaving, you should say that ain't an airport. No need to announce your departure. This ain't an airport. You don't need to announce your departure. I love that, Patricia. Oh, Singapore. Sorry about that, Ahmed. Isn't that something? Like, I think it was like the second chat this morning. I like somebody said, don't let the door hit you on the way out. South Ball is in Southeast Asia. North Carolina, 8:40. So you're on the same time zone I am, Karen. One 140 in the UK. It's so nice, isn't it? That we're all in different time zones, but we can all meet in one spot. Saigon. Good morning, Banana. Yeah, he knows his tech. I think all of Corbett comes in. I hope so. I hope so. I don't understand why people complain to the content creators. Millions of free channels to choose from. Just go away. Exactly. Just go. Really, I didn't know that. Good morning, Lori. You have people from all over the world watching and supporting, right? Justice for Dan. Rochelle, you are an international channel. Yay! I made it. He's clearly an expert, Jersey girl. Yeah, in my eyes, he's clearly an expert. So we will see. We will see what happens today. 7:43 a.m. in Texas. I like Texas. Or don't let the door hit you when the good Lord. Oh yeah. You're not getting me to go off the rails first thing this morning, Patricia. Oh boy. You guys are great. I love how you make us all feel at home. And that's what I wanted, right? I didn't just want one of those channels, a reaction channel, and just, I wanted a community. And we got that. So people like, I don't even know what its name, Frog, can just go find another lily pad. Houston is nice this morning. You did give your best shot. Oh boy. You go 15 minutes so you can go off the rails for that long. Yeah. Find a new lily pad. Now that would have been rude, right? If I said, you know what, Frog, just go find a new lily pad. But I didn't. Imagine the yesteryear's communication was by Morse code, right? And you know what? Funny you said that, Belle, because I was thinking last night when I was watching Charlie and all that crazy blinking he did. I'm like, I wonder if he was thinking he was smart enough and he was trying to send Morse code to Wendy. Because his eyes were going like a mile a minute. Oh, jeepers, I need to learn to shut that off somehow. Like I wouldn't put him past him to think he's that clever. Yeah, that you're right. It's funny though. Hey Shraz, I'm in Chapel Hill near Brenham, about an hour northwest of Houston. Do you think Frog is on was Bubba or Glenn? I no, because usually Bubba or Glenn, they don't change their picture. I wrote down a few names that Bubba and Glenn use, but I don't know because I haven't seen them ever in our chat before. I've never seen that person in the chat before. So I don't know who it was. Like I said, find a lily pad. I watched your channel just 2 days ago. Love your style and this chat. Subbed right away. I spent 4 years in college in Cambridge, Massachusetts. Have been down the courtroom trials for years. Have been down the courtroom trials for years now. Well, we're glad you're here, Ahmed. We're glad you're here. But one thing about Charlie, he was calm and comical throughout the trial. Yep, he definitely was. I'd tell him to act like a cow patty and hit the trail bye-bye. Good morning, Debbie. Good morning, the morning feed. It's Fugitive Friday, listening with witch hunting. Hope you are all having a good day. We are now. Yeah, I haven't either. Oh, and speaking, Glenn sent me a message that all I had to do was ask him to leave and he would have left. He didn't need to be put on timeout. Hey, Matt, I drive through there about 4 times a year. Blink and you almost miss it. Love that part of the state. Oh, oh, you're hunting. You got us out while you're hunting. Isn't that something? The Adelsons are not clever. Not even Wendy. She sure thinks she is. They sure do think they are. And Charlie was very belligerent with Georgia. Condescending, arrogant. I thought today was Wednesday. This week flew by. I know, so did I, Jamie. Hunting predators. If you see an Adelson, bag us one, would ya? That was kind of clever. I got a little clever this morning. I hope he spills the beans about the WA dinner. Yeah, Wendy dinner. It doesn't make sense. No. I still think, yeah. Patricia's trying to get me off the rails first thing. I still think that he, with his sick humor, probably thought it was funny to go off about what might a Dan look like or any of this, and she vomited at the table. That's what I think. Ha ha ha! I oddly have caught a few Adelsons. Convicted in 3 hours, including lunch. Think Georgia's got the last word. Yeah. Hello, Dottie. Hello, Lee. Hello, Swirl. Top of the morning, folks. We got 10 minutes, guys. Yeah, Wendy going to the crime scene was genius. Like, honestly, I genius because it nails her, but there's criminals out there, like, they say people that start fires and stuff like this, that they go back to watch the rescues or they go back to the scene. That's exactly what she was doing there. Good morning, Vegas. Hunting. How do you hunt and keep up with the show? Now that is amazing. Yep. I think Wendy vomited because of the massive adrenaline rush she was experiencing. Yeah, that could be too. And, she said in one trial, she said it was 2 weeks after. Another trial, she said it was a month after. So, and she hadn't eaten anything in that time because she was so scared. So she only drank her meals. So maybe as soon as she put some sushi in her guts, she puked. It sure does nail her. It's going to convict her. I think it is too. This Donna pic creeps me out. I know it creeps me out too. Not just going to the crime scene, not trying to find out what happened when she saw the police tape. Right, not getting out of her van saying, hey, is that at my ex-husband's house? Anything. Curious as how Donna will dress and appear for trial. I think they're going to dress her like a 50s, 60s, 70s librarian. That's where I'm going with it. Maybe it was just a story to tell Jeff how upset she was. No, well, one would think it would have been just a story, but she confirmed it, and so did Charlie confirm it. So maybe that caused her to vomit, possible. Yep. I realized this week I've spoke to everyone here more than people I live with. Good chance. Wasn't kosher style. No, definitely wasn't Jersey girl. Was not kosher style. I don't think anyone could go without food for a month. How would that be possible? Just another one of her stupid lies. Yeah. Yeah, it because Jeffrey said it was a couple weeks, right? After the murder, but she wanted to exaggerate. She has to exaggerate it all the time. It's insane. Good morning, Dennis. Watching you from Sarnia, Ontario. I am from Belleville, Ontario. Welcome. Sushi is not kosher. No, it is not. Like all the female defendants dressed like a Mennonite. Mm-hmm. Yeah, Karen. Yeah, it was another lie. She's so full of lies that I can't even imagine the extra lies we're going to hear in this trial from her. But we have 81 watching, everyone. Let's hit that like button. Orange jumpsuit and change would save time. Yep, exactly. Just put them all in jumpsuits. Oh, imagine how many people are. So we're hopping. Look at hello, my friend. Hello. Hello, Ian. We're up too. I don't want to be, but we are. Ian, you missed it. We had a first troll already this morning. They'll be out thick for this right now. They will be out thick. I was thinking last night that, you know how I say sometimes the trolls are either Wendy or Honeycutt or Tova or Rashi. I bet you John Laurel's got a few for himself. It was a low effort troll. Yes, it was. Tried to, it's just, blah, go away. Hey, all, I'm at work trying to watch this when I'm not busy. Hey, 3D, welcome. I'm just wondering, do we get another goodie from Rashbaum today? Do we get another Freudian slip from Rashbaum? I hope so. I wish they could put a shock thing in the chair. But every time, sorry guys, that every time she lies, she gets a shock right up her arse. Can we have the buzzer? Can the coffee crew have the buzzer? She'll be jumping like a good thing. Frog is on his Rashi. That would be funny. Yep. I know 3D. This trial can't start soon enough. I wish it was here now. I thought about that too with Sarah Boone. Can I have that buzzer? I would love it. Oh, we aren't disputing Ms. Adelson paid for the murder. I know. I watch that all the time because I laugh. I think I laugh more at my reaction to it than anything. But the guy is such an idiot. Good morning, sunshine. See, Donna lost her sunshine, but we got sunshine. Good morning, Julia. Good morning. Am all got my coffee. It's still dark in Vegas. Oh, wow. Hello, pizza driver. This case is this generation's gaudy mob trial. Cheers from South America. It sure is. Hey, Share Bear. Long time no see. 2 minutes, guys. Wendy, I tried helping police as much as possible. Also, Wendy, I hung up on the Detective Isom when he called me, right? 3D, right? What time will the trial days start? 9 a.m. Oh, you said, I think you said listening while getting ready for work. And I said, right, because I think it's a lot of people are doing the same thing. We heard that one. Sorry, I don't want. Everybody got your banana bread for breakfast? Hi, 10. Hi. Wendy. Oh, it's the camera person.
Morning. Of course she did. To do it.
Oh, fix down, long time.
I already did.
Ruth family asking to be on Zoom once again.
I do not know the answer to that, Judge. I'm sorry. Let me confer. I think we should probably assume so.
Oh, and I see a tile labeled Ruth Markel.
Okay, then yes, Your Honor. Thank you.
Do you have any idea who Misha Janice is?
I do not.
The only reason I'm asking is because in the last hearing, someone joined Zoom who's doing inappropriate things. So from here, the Zoom is going to be limited. If I get wind of anyone else trying to do inappropriate things in the midst of the Zoom, ultimately it's just going to be, if you're here, you're here, you're not, you're not. I'll go ahead and allow all parties to make their appearances for the record.
Georgia Kappelman for the state, Your Honor. Sir Calvin Dugan for the state.
Dan Markel on behalf of Ms. Adelson, who's present. Adelson Morris on behalf of Ms. Adelson.
Very well, let's go ahead and move with the one hearing that was scheduled for today. This is the defendant's motion in limine concerning the testimony of Sergeant Corbett and the summary exhibit. Whoever's arguing the motion may proceed. You may.
Judge, I think we filed pretty detailed papers on this. So I'll quickly summarize, and then if you have any questions, I'm happy to answer anything that you have. I think it's really important to realize we're not asking that he not be allowed to testify. What we're asking for is two pieces at this hearing, and there'll probably be more during trial regarding actual pieces of his testimony. So that's the third piece. The first thing we're asking for is that he not be qualified as an expert. We don't believe, as set forth in our papers, that he's testifying to anything that meets the standard of Florida statute 90.956. And so we don't think he meets the qualifications of an expert in what he's testifying to.
You mean 90.702?
I'm sorry, 90. Correct. We don't think he meets those qualifications. We think he is a summary witness, not an expert witness, and we think his report illustrates that. The report itself has essentially 5 components. It has emails, which are a culmination of emails that the state has taken and put in a report. Text messages, neither of which emails or text messages is he an expert on. He's just compiling them, putting them in a report. Video surveillance photos, and then it has call record summaries, which we'll get into, but takes no expertise to do the call record summaries. Florida law is pretty clear on that, as well as cell site data, but it's very limited to cell site data, especially with regards to Mrs. Adelson, who's on trial here. There's some more detailed cell site data with regards to Mr. Garcia and Mr. Rivera, but even that wouldn't qualify as expert testimony. The cell site data as to Mrs. Adelson, there really is virtually none of it. So
one question before we continue on track of the expert testimony. As it relates to items that the state can properly admit, and I'm sure that based on the pleading, there are aspects of the current PowerPoint that are disputed as being inadmissible. But for what can be properly admitted, are you also disputing that those cannot be used as a demonstrative during trial by the state in some way?
no, they can be. So in other words, there's no dispute that they can use the report as a demonstrative. There's no dispute that for the admissible items, they can put in the admissible items. So I'll give you an example. Email between Wendy Adelson and Donna Adelson. Clearly it's admissible, provided it's relevant. The ones they provided are relevant. Clearly admissible. The underlying email can be admitted, shown to the jury through an appropriate witness, if they call Wendy Adelson, for instance. Okay, so that email is admissible. But the summary of the email in the exhibit, the summary of the 1 or 2 page email in this exhibit can be shown to the jury, but it doesn't qualify as expert testimony or a proper summary exhibit to be admitted. Does that make sense what I'm saying?
It does. The one thing I would question, even concerning the demonstrative, are you also saying the state cannot put the context around these various pieces of evidence?
No, they can, right? They can make arguments just like they do in closing arguments, right? They can show the exhibit to Sergeant Corbett. He can put it on the screen. He can explain whatever he's going to testify to. Our argument is he's not an expert in doing that. That's our first argument. And our second argument is ultimately that 329 pages right now doesn't go back to the jury. It's a closing argument, essentially. When you look at his 329-page exhibit, and again, I'm getting a little ahead of myself, but when you look at his 329-page exhibit, it's essentially Ms. Kappelman's closing argument, okay, which we don't admit to the jury. The jury doesn't get her slides and see them in the jury room when they're deliberating. But no, of course, they're able to provide its admissible material in it. They're allowed to show the exhibit. They're allowed to use it as a demonstrative. They're allowed to question Sergeant Corbett. He is allowed to be a witness based on what he did. Our argument is, number one, he's not an expert, and number two, the actual exhibit is not an appropriate summary exhibit that would go back to the jury during deliberations. That's what our memo is about. And it's supported, Judge, by Florida law. So the Florida Supreme Court has held that law enforcement testimony, which merely summarizes and explains data from cell detail records, including the mapping of cell phone location data, is not expert opinion under Florida Statute 90.702 and Daubert, because it involves no scientific, technical, or other specialized skill. Cites King v. State 260 SO 3D 985, Florida 2018. McMillan v. State 214 SO 3D 1274, Florida 217. The Florida Supreme Court has supported that, and also has the 11th Circuit in Batista, B-A-T-I-S-T-A, in affirming the Florida Supreme Court, where the 11th Circuit of Court of Appeals affirmed the district court's decision to admit as lay testimony an FBI agent's use of cell phone records, along with the phone company's records of where their cell phone towers were located, to plot on a map which towers connected with which cell phones at a particular point in time. But it said it wasn't expert opinion. It said that you don't need the agent doesn't have any expertise to read the cell phone records to determine which cell tower was used at a particular time, look up the latitude and longitude of that cell tower in the company's records, and mark the intersection of the latitude and longitude on a map. That's precisely what Sergeant Corbett is doing here. It is exactly on point to what he's doing here. Also, the fact that he pulled data off of iClouds and he pulled data off of iPhones, it's not an expert. Now, of course, he's able to testify to it, but it doesn't meet the standards of expert testimony. Now, moving to the second point, Judge, which is whether...
Before you move on to that, when it comes to the data pulls, because I've heard this argued, not by you, but a number of ways over the years. The first being the data pull itself is a factual issue, which I would agree. How the machine works and whether or not the data pull was in fact, it took place technically in a correct manner, that goes to more specialized information. Is there going to be any contesting of any way that the data pull was somehow not technically proper or sufficient? Because if so, at that point, now we are veering into a matter that deals with specialized information, knowledge, or expertise.
Judge, may I have one moment, please?
Go ahead.
You stipulated to that. That's one of the things you stipulated to. All right, so we'll have to figure that out. Okay.
Judge, I don't believe it's going to be an issue. But we understand what you're talking about. If it were to become an issue, then obviously the expertise on that particular issue would be obviously subject to his qualifications, which we think he has. Okay, but at this point, we don't anticipate it being an issue. We don't anticipate. There may be questions as to why he pulled it as opposed to someone else pulling it. But as far as whether it was pulled appropriately or not, we're not contesting that.
Very well. You may continue.
Okay, so Judge, if I may just move on to the second part of the argument. The second part of the argument is not dependent on the first. So whether he's an expert or not an expert, it really is an independent inquiry, the second part of the argument, which is whether ultimately whatever turns into his exhibit, his demonstrative, goes back to the jury. And again, for purposes of today, unless you want to go into it, I'm not going to be talking about specific pages that we don't believe are admissible. So let's just talk about the thing as a whole, if that's okay with the court. So, Judge, this summary, and I think you've had an opportunity to view it. It's not, the first thing to understand is it's not a neutral summary. That's the first thing to understand. The second thing not that alone does not end the inquiry. It's just a fact.
Well, to that, and obviously a criminal case is different from a civil case, but all the time, in civilly litigated matters, parties will have presentations, reports, summaries prepared. The plaintiff, by nature, is adverse to the defendant. Anything that they're preparing for the jurors is going to advocate or in some way demonstrate why I should win. As it relates to this summary, the state is preparing this in anticipation of litigation to advocate their position. Why is this inappropriate?
That alone, that fact that it's not neutral, is not the determining factor. But it's one that courts would tell you to look at in deciding whether it is a summary that's appropriate to go back to the jury, or whether it is more in line with a closing argument, which would not be appropriate to go back to the jury. So I start with that just because it's just as a basic factual point. I don't think it's determinative of your decision. What is determinative of your decision, though, is when you look at this summary, it's full of items. Again, we're not disputing that the items are admissible. Let me be clear on that. So the summary has, for instance, I think at last count, 30 to 40 emails. Those 30 to 40 emails, provided they survive evidentiary challenges, are admissible. But a summary is done for the purpose of taking voluminous records and synthesizing them in a way that helps the jury. That's what the statute talks about, right? And that's what the case law talks about. That's what Oloyede talks about, which is 933 F3rd 302 310 4th Circuit 2019, where it talks about how we don't send closing arguments back to the jury. That is not admissible under law. Because summaries are elevated under Rule 1006 and also Florida Statute 90.956 to the position of evidence, care must be taken to omit argumentative matter in their preparation, lest the jury believe that such matter is itself evidence of the assertion it makes. So in this document, you see a bunch of items that are not voluminous. They're one page. Rental car agreements. There's no summary needed for that. 2-page emails, 1-page emails. There's no long emails. 1-page text messages. Not necessary. And then you see call records and you see some call summaries. Again, not voluminous materials. I wish they were, but they were limited in what the call materials were. So, Judge, our argument is that the exhibit itself can be shown. We're not arguing that it can't be shown to the jury.
As a demonstrative, but not as admitted evidence.
Admitted evidence. The underlying evidence in it that's admissible can be admitted, obviously. Now, within the summary, and I think this may be better taken up at trial or in another day, unless you want to take it up now, within the exhibit, we
hold on. As to any pages that are specifically disputed as inadmissible, it's best to handle this outside of the presence of the jury, so that way it's clear what is in and what is out when all of it is ruled on.
Yeah, so I mean, we can do that at your convenience. Look, the state has still been updating it, so things may change, but we already see some pages that are either hearsay or privileged under the joint defense privilege, for instance. We already see, there's not a lot, but we already see some pages that we think are problematic, and we can take that up whenever you want. Our argument today summarizes on his characterization as an expert, and either way on the document actually going back to the jury.
Let's handle that part of it then next Thursday if there are still disputes as to individual pages, so that way it can be handled and ruled upon.
Okay, thank you, Your Honor. If you don't have any questions, we'll rest on our papers.
Very well. State, you may respond.
Who's doing it?
Morning, Judge.
Good morning.
So the defense motion argues that, you don't have to be an expert in order to testify to phone evidence. And they cited the King and Gordon cases in their motion and talked about them this morning. I think it's important to consider that in both of those cases, which were post-conviction motions, where the court said that the defense was actually not ineffective for not getting their own expert, or not objecting to the witness testifying for not being an expert. The defense did not object to a non-expert law enforcement officer testifying to the cell phone evidence in that case because it was a strategic decision. The defense knew that they could cross the law enforcement officer more effectively than an expert, and the state could easily get someone more qualified had the defense objected. In Gordon, the court said that the witness from the phone company who testified would have qualified as an expert to testify to that data and been able to testify to the cell site data had there been an objection. In King, in that post-conviction evidentiary hearing, the defense put an expert on the stand who provided expert testimony on GPS and on cell phone location data. The defense expert concluded that the defendant could have been at home, not at the crime scene at the time of the murder. So in that case, there was an expert who testified to the location information from the cell phone records.
That does lead me to my first question concerning Sergeant Corbett. What exactly is he going to testify to beyond what the cell phone data history records or cell phone tower records would show? That or otherwise you need him to testify through an opinion, that he cannot just testify off the records themselves.
Yes, sir. So he's going to be, and I have this in just a second, but as far as the summary goes, he's not testifying as an expert to everything in the summary, but he's testifying as an expert to a large part of the summary when it comes to cell site location data and how far, who's using a handset at the time and how far the person is from the cell site location. He uses the more.
So you're saying how to interpret that data?
Yes, sir. And he uses more than just cell phone records to do that. But the cases, the Gordon and the King cases, those cases say a witness does not have to be an expert to testify to some of that information. But they're not saying that you cannot present an expert to offer an opinion on a handset's location. If that witness has the necessary training and experience, just as was done at the hearing in the King case and could have been done at the trial at the Gordon case. And Sergeant Corbett has hundreds of hours of training and experience and has offered an expert opinion well over 100 times in circuit court. The reason they don't want him to be able to declare an expert, they don't want him to be able to offer an opinion. And this is more than just a data pull of, hey, we got these cell phone records. And this is more than just, this is where the cell site locations are at any given place in Florida. This is him forming an opinion on how far a handset is from a location, who may be using the handset at the time that you need this specialized, or that it's beneficial for the jury to hear his specialized knowledge because he's able to interpret the cell phone records to tell us that information. The defense also argues in their motion that there's basically just too much evidence in this summary, that it's more than just for phone records and some of the evidence isn't voluminous. But a summary's whole purpose is to summarize relevant evidence. Sergeant Corbett, as I said, is not offering an expert opinion on everything in the summary. He's offering an expert opinion on the interpretation of the cell phone records, the location of the handsets, who may be using the handset at the time. And there's a large part of the presentation that are those things, but there's a lot more information in the summary, like surveillance video from Premier Gym, a traffic ticket received by the suspect, a car rental agreement, that maybe those things individually aren't voluminous, but they're all material to the presentation and material to his opinions because he's using them to provide an opinion on who had the handset and where the handset was at the time. For example, if a certain suspect's phone is communicating with a cell site that's consistent with like a car rental company, an expert may be able to better determine who was using the handset at the time and confirm their actual location and confirm the reliability of the cell site information. If we're able to see that, well, that person actually got a rental agreement at the time, they got a traffic ticket shortly after the car was rented, all of those things help him form his opinions and determine that. The defense says, this is a closing argument. The information that he looked at in this case, there is so much digital evidence that it is very all-encompassing. However, there's not, what's in the presentation is not all data. It's messages, it's emails, it's different business records and cell phone records that we received that helped inform those opinions. They talked about the 30 or 40 emails. When I'm handing them over the things that I may use in my presentation, I'm trying to be as thorough as possible. I don't want them to have less information than I may use. I don't intend to use all 30 or 40 emails. I don't intend to have Sergeant Corbett sit up there and read all of those, but I wanted to send them all of the ones that I may use as far as just, these are what was found in these different accounts. This was and asking him, hey, did law enforcement find some evidence of motive that caused him to look into these people? Yes, X, Y, and Z were found. Maybe spend 3 minutes to 5 minutes on that and move on to the next thing.
As to that point, and I believe the defense's motion hits on this as well, for what you have asked Sergeant Corbett to add to this, is that in fact his opinion?
So The defense motion attacks that, the prosecutor is ultimately deciding what's going into the presentation. Maybe that's what you're referring to.
Yes.
But Sergeant Corbett's job is to pull information from these devices, interpret that data from the cell phone records. He's not investigating or prosecuting the case. In the investigative phase, he has to rely on the investigator to let him know what he's looking for, what this proverbial needle in the haystack is, whether he's wondering it exists. And Sergeant Corbett's then looking through the records to see if there is one, and then if there is one, including it and letting them know. Sergeant Corbett doesn't know exactly what the prosecution wants to present at trial. I talk to him about what the records show. I ask questions. He looks for answers, lets me know what the data says, and then I'll say, yeah, can you put that in there? I think that's important. He's not the one talking to witnesses. I may talk to a witness. They tell me a certain event occurred. Then I go back to Sergeant Corbett and say, hey, is there any evidence of X happening? And he lets me know that. That may corroborate what the witness says, and then we're able to put it in there. And I'm not able to get that information in any other way because he's the person that's looking in these cell phone records and can let us know whether that evidence is corroborated or not, and can provide an opinion on what the data shows, where that handset was at the time, where that how far they were from the tower at the time, things that may corroborate witness testimony or appear in the cell phone records that I wouldn't be able to see or know on my own. The defense motion also argues that the summary isn't admissible, but summaries are admissible. That's the whole point in using them, and there's no case law that I know of that says otherwise, that a summary isn't admissible and has to only be used as a demonstrative, and the defense doesn't cite any either. The defense has specific objections to certain slides because of hearsay or privilege or other things, which I'm ready to discuss at any time the court is. But as far as the summary not being admissible, there's no case law that I know of as to that. And the defense hasn't cited any either. That's all I have.
Very well. One question about the document itself. And I think this is really what goes to the heart of the defense's motion about the summary. If you're taking, say, thousands of pages of documents and you reduce them to, let's give it an arbitrary number, a 25-page report, you have synthesized the larger to the smaller into something that is digestible for the jury to use in making their decision. That, or at least in their position, is not argumentative. Some of these things are more or less a part of the state's summary, at least as it stands right now. Mm-hmm. It's showing corroboration of other evidence. Is that in fact a summary in the sense that the statute defines a summary?
Yes, sir. I mean, this is the things that may corroborate other evidence, though, help this expert form his opinion. As the example I gave with the traffic ticket and the rental agreement, he's able to, from the phone records, say this phone is consistent with this cell site at the time. They may be this far from there, but as far as showing who has the handset at the time, like who's talking on it, and how far they are from it, it's all of those other evidence that helps him form his opinion.
Very well, thank you. Brief response, if you have one.
Really brief, Your Honor, and I just want to make this clear, and I think you understand our position perfectly. We're not arguing that summaries are not admissible. We're arguing that this is in the proper summary. That's the argument. We don't make an argument in our papers that summaries are not admissible. We're saying that this document doesn't meet the foundations of the Florida statute as a proper summary. Again, they're taking particular points, but these are not voluminous documents that they're now summarizing. So there's only one voluminous document that they're summarizing in this entire presentation, and that's how they got originally to Harvey Adelson's phone number, where they had data that would go to the ceiling. If they wanted to do a summary exhibit on that piece, it might be allowed. But everything else is not voluminous materials. It's a closing argument. To allow them to put that document to the jury would essentially be the same as saying, you know what, Ms. Kappelman, Ms. Dugan, when you do your closing, the PowerPoint that you do, that should go back to the jury too. Because it's essentially the same thing, Your Honor. There's no difference. That's all I have, Your Honor.
Right, concerning this motion, I'm prepared to rule on part of it today. As to whether or not Sergeant Corbett can be properly qualified as an expert witness, I will find if Sergeant Corbett is capable of testifying to the interpretation of the records that go beyond just merely where the towers are, what was pinging, and what the phone records show, that would go to scientific or technical expertise in which he is properly able to give an opinion. As to the summary itself, and I do not want to belabor this point, but I do believe I am going to need to hear from Sergeant Corbett specifically as to how he put this together, and his opinion was informed by the information that is in the summary before I can rule on it. Otherwise, I agree with the defense position. This is proper as a demonstrative, but to admit it as evidence, I'm going to need to hear more. We'll have part 2 then, in which Sergeant Corbett can testify concerning how the summary was created and how his opinions were formed by the evidence that are within the summary after we have the docket sounding next week. As to another matter which I am prepared to rule on at this point, concerning the defendant's motion in limine, concerning testimony from Wendy Adelson as to the storyline of her book and also changing the names of the children. I will permit the state to use this information for impeachment, depending on what is developed during the examination of Ms. Adelson. As to the other matters concerning her testimony, that has already been ruled upon. Has the state also decided which jailhouse recordings you're intending to use for evidence? Because I did need to review those.
Yes, sir. As of right now, we do not have any jailhouse recordings that we intend to introduce that feature Mr. Adelson, which is what the defense was objecting to. So that's why we have not sent any to Your Honor. May I clarify what you just said about the name changes?
Go ahead.
You said it could be used for impeachment. May I? She admits that point, or has previously. Would I be permitted to inquire about that area?
As it relates to any prior testimony she's given on the subject, you may inquire as to that. Very well. I believe still outstanding.
Judge, I'm sorry.
Go ahead.
I just want to make sure I understand now. So our motion was to prevent them from inquiring as to the name changes. So in other words, our motion was Ms. Kappelman or Ms. Dugan can't ask her the question, did you change the kids' names? That was what our motion was. So I'm just not sure the ruling. Can they ask that question?
Well, on that particular point, what is this being offered for, Ms. Kappelman?
For motive, Judge.
As it goes to motive, I will permit it for that reason, or also impeachment, depending on what comes out. Motive and bias are equally available for both parties to explore. All right. As to the state's motion in limine, I believe there is also one other outstanding item to be addressed concerning Ruth Rivera's gang affiliation. As to this particular point, and I researched this further, Mr. Rashbaum, as to the name of the organization, I'm really failing to gather why hearing I was threatened by a gang member versus I was threatened by a Latin King member is going to in some way create a greater credibility in front of the jury for the narrative that you wish to weave. I will permit Ms. Adelson, if she testifies, that she acted in accordance with being threatened by a gang member. The specific name of the gang, I don't believe in any way is going to assist the trier of fact in terms of assessing her story, whether it's credible or not. They will make their determination if they believe this testimony. believe that was the only other outstanding matter of the state's motion in limine. As to Jeff Lacoste, I have not finished my research yet on that matter, but I will rule on it before we start with any selection of the jury. Do the parties have any other matters that we need to address this morning?
Yes, sir, just a second.
Judge, in contemplation, like of planning when to start evidence, can we all agree that we would not start the presentation of witnesses until Friday, the first Friday?
Assuming that we have the jury selected Thursday.
Yes, sir.
Well, that would probably be appropriate. Does the defense have a position concerning those?
You have one moment.
Go ahead.
That's fine, Your Honor.
Very well. Assuming we have a jury by Thursday afternoon, we would start with the case on Friday. Well, would the parties be able to go into their openings, assuming there's enough time Thursday afternoon?
Yes, sir.
Mr. Rushbaum? Very well. If we have enough time then, after we have the jury selected and sworn, we would give openings and then launch into the testimony from there with all the witnesses. Does the state have an idea, at least in terms of days, how long you think the case in chief will last?
I think 6 to 7 for our case in chief, Judge.
All right. Does the defense have any idea at this point?
I would say, it depends, obviously, but I would think 2 days.
Very well. No one's going to be held fast and firm to this. I'm just asking for an estimate. One other matter to address with the defendant directly before we finish this morning. Ms. Adelson, next week we are going to have your final pretrial. That is typically the hearing in which I inquire of both parties if they are in fact ready to go to trial, if any continuances are necessary, and also information concerning plea offers. As I stated to you at a previous hearing, I do not prod people to take pleas. However, if you wish to consider a plea offer from the state, the time is rapidly coming for you to make that decision as to whether you desire to entertain any plea offer or not. If you want your counsel to provide an offer to the state, also the time is coming very close to a conclusion for them to do that as well. I'm not going to prod you either way, but I want you to be mindful of the fact, once we begin jury selection and the denial is sworn, that means trial has started. From there, basically because of count one, if you are convicted as charged, my hands will be tied concerning any sentencing on that matter. Your attorneys will have further discussion with you concerning this, but if you are considering anything at all, you need to make a decision on this quickly. Do you understand where I'm coming from?
Yes, I do.
This is a bad
Very well.
person.
We are in recess. I will see everyone next week at 9 o'clock, September 12th.
Okay.
Yes, sir.
Maybe we briefly go sidebar.
Yes.
Oh, that's quick. That was quick. She's in Austin.
Sounds like it's okay. Sorry, I know. That's clear. I understand. Okay, that's your job.
Make it out.
That is the conclusion of the hearing for today. Have a good Friday, everyone. We're in recess.
That was quick. That was so quick. No, we don't want you. Nope. That was so quick. Okay, I noticed Shiraz. Shiraz, you thought that was pretty bad about Corbett there? I'm just trying to get back to it. Let me get this. Where is that? Let's get that off. I thought it was pretty good about Corbett. I'm okay with the fact that he wants to hear from Corbett. I think he's just making sure he dots every I and crosses every T, because the fence did not want that whatsoever. Hello there. I don't even, Paul, honestly, I don't think there's anything on the table. It's just Everett making sure there's no holes. And I am shocked that if they are done picking the jury Thursday morning, they're going to jump right into opening statements Thursday afternoon. That is shocking. Not bad. I just don't understand why Everett isn't just going to make Rashi challenge it on cross. It's been admitted to every trial up to now. Yep. I think it's just dot every I, cross every T, make sure she doesn't have any loophole for an appeal. Oh, I don't see. I think if they played too much, then Everett's going to freak out on them. He doesn't play well with people delaying stuff. Oh, she asked for a speedy trial. She wanted it as quick as possible. So I'm glad she's going to try. Could you imagine if we had to? Oh dear. So Wendy's book is allowed. Wendy's changing the boy's name is allowed. Honestly, I don't think the defense got anything today. Really. Yeah, I can't even imagine what kind of deal, because they're not going to make any deal that doesn't put Wendy in jail. She wanted speedy because she thinks she's still going home. Yeah. I got pulled away after the last sidebar. Does this mean anyone is entertaining a guilty plea? No, I don't think so. Because I was watching when they turned the camera back to George. It didn't look like she was just not even looking over. I think he's being very cautious with her. Sorry, guys. She can always appeal, but with how Everett handles his courtroom, I don't see how she will get a new trial on appeal. Everett is just too thorough as a judge. Exactly. And I think that's exactly what he's doing here. Nothing sent alarm bells off for me. Is Donna your mom, Wendy? I'm sorry. Is that a question? Yeah, right. Yeah, right, Jamie. It only means judge is saying Donna should be begging for a deal. Yeah. The deal thing. I know a lot of people that's going to trigger them, but I think Everett's just exactly being Everett, making sure everything's right. If she takes a plea deal, Rashi still gets the millions. Yeah. But I kind of felt Corbett stuff would still come in because it's been, what, 3 trials? They've let him have this 3, testify against all this 3 trials. So good morning and happy Friday, everyone. Good morning, Amby. Oh, it's just, yeah, there was a lot of, sorry guys, I didn't, no, there's no plea. There's no plea. I wouldn't let that get to you whatsoever. Just, that was a bad camera person though. Long crime, that's a bad camera person. They were more focused on Judge Everett. That's exactly right, friends. He is saying, look, there will come a point where you are looking at life without parole, and there's nothing he can do to stop that. He's just making sure she knows that. Yeah. We all know, we've been through Charlie's trial with him. He's very thorough. He's a great judge. She won't take a plea. There's no plea. Like I said, she said, I need to save my family. She must have ordered that as she thinks she's so in control. No, she has no say what that camera does. It was just a bad camera person today. Yeah, it's going to be in this courtroom. Very bad camera person today. No offense, long crime, but your camera person just didn't cut it today. And Shiraz, you're right when you said about Friday court. That was I'm shocked that if they get their jury selection, so the 17th is, oh, no. Oh, yeah. So 17th is Tuesday. So that gives them Tuesday, Wednesday. And then the 19th is Thursday. So if they have their jury picked by the morning of the 19th, they're going to jump right in. Oh boy. We are going to be busy people. I agree with Rochelle. The only way she doesn't face the max is if she turns on Wendy, and I don't see that happening. No. Because no matter what, it doesn't get her boy. It doesn't get her sunshines because she's still going to be in jail. That's 2 days for jury selection. That is wild. So we could be like, oh, that's going to be a long day. If Thursday, oh, it's going to be a long day. Let's get our popcorn ready, people. Oh, okay. So now I'm going to have to redo the calendar in case there's a Thursday trial day. Wow. I thought the Corbett stuff was going to go longer. I really, truly did. Sunshine, she has limited immunity contingent on the facts that she tells the truth on the stand. If she lies, her immunity is instantly revoked. Yeah, and they haven't yet revoked it, and she's lied many a times. But the minute they still want her to testify, right? So the minute they revoke it, she's not going to testify no more. I see Charlie turning on Wendy. We will see. Yeah. But like everybody said, there is not a way for Charlie to get out early. There's just no way for even him turning on, because no matter what, he's got the life plus 60 years. So he's just never getting out. So if he turns on Wendy, it's just because he truly just is pissed, to be honest. That's it. He's just going to do it because he's like, screw you, sister. I'm in here and you're going to be in here too. It could happen. Like I said, but there's no feasible way for him to get out early. He would have had to do it prior. Charlie's jury selection, that was, I'm trying to think back, was that 2 or 3 days? I think it went 3 days. No, but he can be in Mummy's good favor by implicating Wendy in Donna's role in the plot. So turn so he can get his mom off and say it wasn't his mom didn't. So his mom didn't know till after the fact, but it was actually him and Wendy. Is that what you're saying, Patricia? Who takes happy smiling selfies on beach with someone you've only met twice? There's more of a relationship there. I agree. That's a crazy deal. Everyone is under oath. Yep. Actually, there is a mechanism in Florida law for a prisoner to provide evidence after sentencing and get a negotiated reduced sentence, which is why Katie is hoping for. Okay, yeah, but even if I understand that. I'm just saying I don't see how he gets out ever anyway. He might get a reduced sentence. Maybe they'll give him a chance of parole. I don't know. But I just don't see it no matter what. He said in a phone call to Donna, it was stupid of Wendy to show up at the crime scene. He said, she is free and I'm here. Donna agreed. I want you to hear that phone call again. I'll look for it. Charlie will turn on Wendy because he doesn't want to see Donna go down. If Donna goes down, all bets are off. But he could turn on for Donna. But Donna's the evidence against Donna is so strong. So I don't see Donna turning on her golden child. No. I don't see any. Honestly, guys, I do not see any of them turning on anyone. I think if you see 5 years down the road, if they haven't arrested Wendy, then Charlie may get PO'd. I just don't see it. Although with that, what Judge just said, his hands are tied once the jury is sworn in, at least on sentencing limitations. Yep. I trust the jury will see the truth. Donna's going away for a long time. Oh yeah, she'll never see outside again. Well, she'll see outside, but she won't see outside those walls. Dottie says, I would love Charlie to turn on Wendy because I don't think Katie or Louise have much info on her. I don't think anybody even needs to turn on her. She's going to get arrested. No, Donna won't turn on Wendy, but I think Charlie will. Charlie is pissed at her. Yeah. It is crazy. I really thought Corbett was going longer. George is setting up Wendy for the big fall. Pardon me. Donna's trial will be about Wendy. Watch. Yep. Just like Charlie's was about Charlie. And so Katie's was about Charlie. Charlie's was about Charlie and Donna. And Donna's will be a good Wendy bashing. Have a good day at work, 3D. It's impossible for us to calculate what they're going to do because we don't know what their options are. We probably won't until the entire case is done and dusted, right? I agree, Shiraz. And another thing, for us to even try to think how an Adelson thinks, your brain's going to explode. Truly going to explode. But it's fun. Oh, they probably got somebody already set up. Who knows? Oh, sorry, guys. Donna will die in prison. That's what Everett was saying to Donna. She is getting close to the point of no return. If she wants any chance to get out of jail, now is the time to talk. Yep. I agree. What if a deal is made with Charlie and or Donna about turning on Wendy, then Donna's sentence reduced and Harvey's left alone? It's possible. Anything's possible. We've seen it. Yeah, Shiraz, but I love a good speculation. Miss Fabulous, welcome. Hi, everyone. Enjoy your weekend and don't forget to hit the like button, share, and comment. Shabbat Shalom. Thank you, everyone. This sure is awesome to watch. All the best. Aren't you just amazing? That's amazing. Anne Marie, I must believe Georgia is holding strong Wendy evidence. Each trial, it drips out. All will be released for Wendy's trial. However, with her in Texas, she is under surveillance. Oh, she is definitely under surveillance. Absolutely. If not for Wendy, Dan would be alive and Charlie would be eating lobster tonight, right? The bitch is guilty. She's a murderer. Absolutely. If Wendy gets off scot-free, I think Tudo has a plan for her the way he was looking at her. Yeah, I don't ever see her getting off. That was really, really nice what Miss Fabulous said. That was a very nice comment. Karen, you make the $1 million point, friend. Wendy is responsible for all of this. Absolutely. Yep. Everybody's saying thank you. Thank you for that. Your comment actually warmed my heart this morning, so I greatly appreciate it. Thank you so much. Shabbat and shalom to you, Miss Fabulous. Happy Sabbath. It was very soon after Charlie was convicted, the phone call. He was oh yeah. Those phone calls are just... Oh, Shiraz, you are absolutely top notch. I'm telling you. Shiraz gifted 10 Crime and Coffee memberships. Make sure you have that turned on, guys. Look at everybody that was gifted. Dragonfly 75. Carrie Sue. Dottie Fergotti. I love that name. Welcome, Linny, Felicia, Christine, Lou. Welcome to the crew, guys. Welcome. Now, because I have my YouTube chat pulled out, I can see who the new members are. That's very nice. Thank you so much, Shiraz. You show this channel so much love. It's greatly appreciated. And as soon as I speak to True today, I am going to be ordering the cushions for the Markels. So they will be so True can get them to him for the trial. Hopefully before jury. I don't know if they're going to be there for jury selection or not. Yeah, you all got to hit the like or they rescind the memberships. Yeah. Shiraz is amazing. Absolutely amazing. What do we got here? So Karen, you got to go into your thing and turn on gifted memberships. But let's see. Yeah. I really expected a long. I'm kind of excited it wasn't a long one. That means tonight we can do our live. Because I thought if it's really long, Karen is a member. Karen D. Oh yeah, Karen, you're a member. Oh yeah, you're green. What am I doing? It's too early. It's too early. I was up. We ended our live 1:30, and then I did some digging around. So it was about 3:30, 4:30 by the time I went to sleep. They can all thank Wendy for Dad being left alone. Yeah, they honestly, I do think that once Wendy goes down, Harvey finishes Donna's other plan. Enjoy your day at work. Well, Dottie, you'll be with us all during the trial then, because we'll be early hours then. Just see in here, make sure. Well, I thought I was going to need 3 cups of coffee to get through that. Maybe X. I'm glad you caught on to the other plan. All right, Jamie, thanks for joining. See you later. Yes, I'm with you for the trial. I'm off now. Thanks, everyone. Toodle pip. See you later, Dottie. Thank you for coming in. What a day. So then, you know what? They're going to finish up on the 12th. So it's just going to be really quick because it's just the rest of Corbett and Jeffrey. So those are the 2 that they're going to cover on the 12th. Corbett and Jeffrey. They really want to keep Jeffries out. And he's really thinking about it. What do you think, Shiraz? Do you think that he's going to keep Jeffrey out? Karen D. Skywarn, try clicking on the button above chat that shows where I gifted and see if it gives you the option to gift. The older I get, the more knackering just changing my bedding becomes. I need to rest now. Yeah, I know. This won't be a long one this morning because we all need to rest. We've all been. If that doesn't work, see if the gifting membership option is accessible from the browser. Oh my goodness, it started to rain here, but it sounded like hail, so I was like, "Oh no, please no snow." No snow. We've had snow. I've had snow here in August. We've had a freak snowfall in August. Ugh. I've had a freak snowfall. I heard it hitting my my hardtop gazebo, and I was like, "What is that?" But it's not. It's just rain. Thank God. You almost see me collapse right on live TV live. Hey, where? Hey, War. Okay. Hey, Win. How could the judge or why would judge keep Jeffrey's testimony? Because they're saying it's just geared. So Rashbaum is basically trying to keep everything out that makes the family look bad. And they're trying to say that Jeffrey's testimony is, it is about Wendy, but I don't know. He's been in every trial, so I don't see it staying out. I just think Everett's just being very careful with it. And I think what Daniel had said, it's basically hearsay. But Wendy can testify to it. Charlie can testify to it. So I don't know. It's really hot here in the UK today and gloriously sunny. Oh, that would be nice. I wanted to know how to gift memberships. Thanks, Shrez. Jeffrey's testimony had nothing to do with Donna at all. Yeah. I hope they can get it in. I think best save Jeffrey's testimony for Wendy's trial. You know, I'm not opposed, really, if they give Jeffrey a trial off. I'm not really opposed to that. Apple doesn't make it easy, Karen. It's going to be 104 in Arizona today. What is that in Celsius? Karen, it's the $ next to your chat box. What is 104 Fahrenheit? Sorry, guys, I'm Celsius here, and I don't know Fahrenheit, so I got to check this out. Oh, 40 degrees. Oh, that's a cakewalk. I know it's not a cakewalk, but I love it when it's 40 here. But I guess it's probably a very dry 104. Our 40 would be very humid. We get 40 in the summer. I love those days. I'm a weirdo, but I love those days. Everybody's hiding in their house in air conditioning, and I'm out. I'm like, yes. I'd like Shiraz's opinion on Jeffrey. Do you think Jeffrey's coming in, Shiraz, or no? I think we lost Shiraz. I have to double check. I think I got a copyright strike from last night from Wondery. I think I did. Patricia Burns. Karen, normally it is one of the options that pop up when you hit that $ next to your chat entry box, but gifting memberships won't show up on Apple devices. I'm same iPhone here, and I can't find a way to join channel or gift memberships. Oh, you can't join the channel. Sorry, busy being annoyed at technology. That's okay. We are not going to be on long. I'll get my laptop out later today and try it there. X, I don't think they need Jeff. I'm pretty sure they have Donna dead to her rights. She signed the checks. This trial, in my opinion, is pretty much a formality. I agree, X. I agree. And I'm like I said, I'm okay with them giving Jeff a trial off. He's been to every single one. In my opinion, he's not needed unless it is to show how Wendy may have caused Donna to act. Okay. I can't imagine Everett not allowing that testimony, and Georgia will find some way to get it in. They might not need it to convict Donna. Yep. All she's got to do is put Wendy on the stand, ask her about the celebratory dinner that she vomited on the table like the pig she is. Oh, Rochelle, it's 10 a.m. in the morning. Watch your language. This is daytime show. This isn't nighttime off the rails. All right, everyone. I greatly appreciate you joining me for this early morning motion hearing. I will be back tonight. To me, they actually have more hard evidence on Donna than they had on Charlie. That's interesting. Save that thought for tonight. I think the wiretap calls between Charlie and Donna will weigh more. Yeah, but they're not. Georgia said she wasn't going to bring them in. Oh, no, sorry. I apologize. Jailhouse calls. They're only going to do the hot mic call, but wiretap calls, yeah. I misspoke. Sia wouldn't want to be... I remember Charlie saying Wendy didn't drink much and had a couple of drinks while they were waiting. Is why she threw up. Yeah. Meanwhile, we all know she drank her dinners. Come on, that girl. All right. Thank you all. It's about 2 of us. Yep, right. It's about 2 of us. What? The 2 of us. I think you know what I'm talking about. Somebody should write that on her wall in her jail cell. It's about the 2 of us. Make her look at those words for the rest of her life. It won't be Danny haunting her. It'll be her own words haunting her. Poor little Wendy. Yeah. See you tonight, all. Hit that like button. It's very short live. What is it? Oh, it's almost 2 hours. See you back here at 9 o'clock, everyone. Thank you again. One step closer, Dan. One step closer for justice. And we will ride it out for you. Thank you, everyone. See you later.